Welcome to Inside the Director Circle and this episode on when and how to use mediation. I'm Jason Langford-Brown, your host, founder of the Director Circle, practicing business advisor and coaching psychologist. In the last episode, we explored the power of mediation. What is it and why is it so powerful when resolving disputes? In this follow-up episode, we'll be looking at when and how to use mediation, the circumstances, when you need professional support, and hopefully discovering some practical tips for you as leaders. To help us with this and to add some expertise to the subject, we're delighted to welcome back Peter Brewer and Clark Wilmot, who are one of our knowledge partners from the Director Circle. Peter is a partner and commercial litigator at the national law firm Clark Wilmot and accredited practitioner of mediation. And very quickly, before we get into the discussion, remember this is just a snapshot of what happens within our business leader community. If you want to get more involved or access further insights, visit directors-circle.com. So Peter, welcome back. Great to have you again. Really enjoyed our first conversation. And I think maybe just to kick us off today, just be worth just to get a very quick summary of what mediation is and why it's so powerful, just for those that maybe missed the first podcast.
Yeah, sure. So mediation is a voluntary consensual process where the parties agree to meet. They agree to appoint an independent third-party mediator. The mediator is specially trained and qualified to try and help the parties get to a compromise position where they can then reach an agreement and resolve their differences.
Right, and I love some of the things we pulled out in that first podcast around how it saved a huge amount of time for business leaders, a big mitigation of cost in legal fees, how it gave control over the process and created so many more possibilities for resolution, which for those that haven't listened to the podcast before this, I'd recommend you maybe do so before you carry on listening to this. But getting into this conversation, Peter, when is the right time to really pull in mediation from your perspective?
I think the sooner you mediate, the better. And I think, as we mentioned in the first podcast, there are probably two key stages when it's best to mediate. I think so. Assuming that you've engaged solicitors and there's been some correspondence between those solicitors, I think when that correspondence comes to its natural end, at that stage you're going to understand what your dispute's about, and you're also going to understand what your opponent's position is. So mediating then seems to make sense. Another natural, obvious time to try and mediate is when, after you've issued proceedings, what are known as the pleadings, which are the documents you lodge at court, set out your respective positions. So the particular claim, the defence, and the reply, and any other pleadings have been lodged at court. Mediating then makes sense because if you mediate after then, when the case sort of moves into a timetable of disclosure, witness statements, expert evidence, case trial preparation, and trial itself, you're then starting to incur real costs. So I think do it as soon as possible. I think another thing I'd say about mediation as well is don't be afraid to be open and honest and to say to your opponent as a part of the mediation process, this is precisely what we think of our position, and this is exchange information in an open way. I think that's a really important thing because then it becomes more effective.
I suppose that's really interesting because we did talk about that a little bit in the first podcast, but I love that point, about having real clarity on where you are now and what our position really is before you start to mediate. It's hard to mediate from a position of unknowing, isn't it? But that open and honesty, I suppose, if nothing else, you're going to start with a position of trust. Then, if you're prepared to be open and honest about where you really are, you're probably going to win some trust on the other side and probably more likely to move forward in a positive way. Would that be a fair description of that?
Exactly.
Yeah, great. Okay. So we that's really useful in terms of when. I suppose the big question then is, who should be doing the mediation? Is this something that any of us can do with a bit of guidance? Can we read a book, or does it depend on the type of mediation? What's your view on that?
So I'm bad to say this really because I'm a qualified solicitor as well as a qualified mediator. But mediators come from all sorts of backgrounds. I would say that using someone from a legal background is probably a good idea. And the reason for that is that if during the mediation someone mentions, I don't know, Part 18 request or a Part 36 offer or some other legal concept or procedural or litigation procedural concept, the mediator is going to know exactly what that is straight away because they'll have been working with those concepts in their legal practice for years. So I think someone that understands, those things is, I think, quite important. That said, don't restrict yourself only to appointing mediators with a legal background. I know mediators that come from business backgrounds or property backgrounds or whatever. It very much depends upon what your dispute is. Assuming you've engaged solicitors to assist you with your dispute, speak to them about the kind of person that you think you could work with as a mediator. A decent solicitor is going to have a whole range of different mediators they've used over the past, and perhaps with varying degrees of success. And it's really, really important, I think, that the solicitor is able to choose for their client a mediator who is going to, help their client. So get on with their client, really. That's quite important. The rapport building bit for a mediator is crucial. But also, that the mediator is going to get on with their opponents as well, and is going to be able to have constructive discussions with their opponents. One of the great privileges in my mediation practice, which I don't get in my litigation practice, is that you get to see both sides of the story. The mediator sits in between the parties as an impartial third party. And if you are able to get to the level where you get absolute trust from both parties, then you get let into their world. And what I mean by that is that they will tell you anything during the process. And that's a real privilege, a real pleasure. And it's something that's very, very satisfying when you achieve it. So I think a mediator that can crack that is really, really important.
I get that point about report, and I think you're right. But it was an interesting risk there for maybe business leaders. We'll pick someone that we like and we get on with. But I think your point about you involving your solicitor because you need someone to give you an objective view that they'll get on with the other side as well. Because ultimately we want to come to some kind of resolution between two parties. I think that's a really powerful consideration because we're really good at picking people we like, but if they don't like the other side or they can't work with the other side, that actually isn't going to help us ultimately, is it?
Yeah, exactly. I mean, there are online sort of organisations that can help you choose mediators. So, for example, as well as being a partner of Clark Wilmot, I'm also a member of something called the ADR Group, which is a membership organisation that refers mediations out to mediators. So you can see my profile, for example, on the ADR Group. There are other organisations that do something very, very similar. Where they have a collective of mediators who publish their profiles online, and then the mediation house, rather like a barrister's chambers, they then allocate work out to mediators. And using forums. I mean, this is why, Jason, this forum is so valuable for me. I think people research mediators on YouTube and on LinkedIn and on platforms like that. Sure. Certainly, I know mediators who are extremely active on those platforms, and people want to see what they're buying, and so they use those kinds of things. One thing that's important to bear in mind, of course, is that a mediator is not appointed by one party; they're appointed by both parties, and so there has to be consensus between the parties as to who they're appointing. And so for that reason, and unfortunately for me, in almost every scenario. If the parties agree to mediate, I'll probably propose anything between sort of 3 and 5 or 6 mediators, and then agree on one that they think is the best for their particular matter. So just because you're approached to mediate doesn't necessarily mean it's inevitable that you will mediate. It has to be something that the parties jointly agree to.
Yeah, absolutely. It's similar actually in coaching. You've got business leaders that want you to coach their people, but they're often put you and several other in front of the people they want you to coach, so that they might like you, but the people that you need to coach need to like you as well. It needs to sort of work both ways. So I get that. I'm going to put you on the spot a bit, Pete. I'm going to put you on the spot a bit now, Peter, because you are a business leader as well. You have a team of people that work for you, and maybe get you to think of some of these considerations in the context as a leader. Because I think about some things you're talking about, and where we have conflicts and disputes within our own businesses and with our own teams, and even maybe with our clients, where it isn't necessarily moving towards a legal situation, but taking some of that non-judgmental mediation skill set and actually putting yourself in situations where you can get parties together and have them heard and get them to talk through their challenges and issues. And I know we talked about that a lot in the last podcast as well, about being able to talk about how they feel. Are you starting to see how those skills are really useful as a business leader just within your own business? Are you starting to use those skills to that effect? I know I've put you on the spot there, but I thought
I think the training does help you in other ways other than actually being a mediator. So if you go and do the formal mediation training, you start to try and, in most situations, you start to try and find a way through them, and you start to try and find a commercial way through them. I mean, we'll talk in a bit about other things that have benefited me as a solicitor, having trained as a mediator, principally around the way that you now prepare for mediations if you're representing a party. There's all sorts of interesting discussions in the mediation community about how deployable this process is. So can it be deployed in something other than a legal dispute? Can it be deployed pre-dispute? What I mean by that is, rather than going off to a solicitor when you're starting, so say, for example, the shareholders in the business are starting to fall out with each other, rather than going and seeing a solicitor, do they each go and see a mediator? And do they sit down and try and resolve their differences in front of a mediator before the dispute goes legal? That's something that's quite common in another forum, which is family law. You know, the parties will very often go and seek counselling before they go off and seek a divorce. And so is there a role for mediation in a commercial sphere in that way? Is there the possibility that mediation could be used, for example, if the parties are negotiating a contract and they come across a clause that is particularly difficult to get through, do they then appoint a mediator to help them with contractual negotiations? Well, maybe. So there's lots of other scopes that mediation can be deployed into. And I think even now, mediators in the market are trying to work out what other things we could do other than just simply mediating legal disputes.
Yeah, absolutely. I think those different, like you say, different granularities of what a mediator can do, different contexts, I think are really powerful. I mean, for me, I think, I'm wondering, you know, I think for me, mediation would be a really useful skill for many leaders to have in their own toolbox. And I don't mean to the extent that you have it where you do it as a profession, but, you know, are there ways that business leaders can kind of go out and find some of those mediation skills and, you know, so they can add them to their toolbox? You know, what could they be doing other than, you know, not going to say, not training like you did, but, you know, what information's out there? Where could they go and access some of this information so they can kind of add mediation at a fairly basic level to their toolbox?
Well, there's nothing stopping people going and doing the qualification. So there are providers like Centre for Effective Dispute Resolution, APR Group, that in the School of Mediation, which is who I trained and qualified with. Those organisations offer training courses, and so there's nothing stopping someone as a business leader who's got no intention of actually practicing as a mediator going and doing the course anyway, because it teaches you the ability to discuss things with people, how to get the most out of people, how to get people to a position of compromise, and how to get people to, for want of a better phrase, to lift the scales from their eyes, to get them to understand in a deeper way their own position. So I think, you know, any qualification is a good thing, and I think the mediation qualification helps you, even if you never actually have any intention of going off and developing a mediation practice. Which, despite the fact that I mentioned in the first session that we had, the fact that there's more mediation work around, and the courts are very keen to push cases into mediation through a variety of devices, including punishing parties with adverse cost orders if they don't mediate, or if they unreasonably refuse to mediate. It is a very competitive market to become a mediator. There's far more qualified mediators than there are practicing mediators. And so, you know, you have to sort of, if you are going to qualify as a mediator, you have to understand that, I think.
Yeah, and it's really, because I see lots of similarities between the coaching skill set and the mediation skill set. And we teach a lot of leaders in my day job, you know, the art of coaching as a way to more effectively performance manage their people, support their people, give feedback, all that kind of stuff. But I think the challenge, I think, for me is that some people are very analytical. They struggle with the language and the context of coaching. And actually, when I listen to you speak, and I'm thinking there are people that I work with that are much more analytical, that actually maybe would prefer the language of mediation to the language of coaching, although I think they do very similar things and get you to a very similar outcome. So I think that's just really interesting as a slightly different kind of thought process. Okay, I'll bring you back on track. I just wanted to take you down that rabbit hole for a second, because I think that is useful. That's why we've got you on the podcast, to get your input into that. But I suppose back to mediation, you know, where should we be doing it? Where should mediation be happening?
Well, I mean, the simple answer to that question is anywhere. It doesn't really matter. That said, there is probably a leaning towards a neutral venue, I think. So do you mediate in your opponent's office or your opponent's listed office? Some people might find that a little bit uncomfortable. I think the bad old days of in the 1990s, where if you turned up to a settlement meeting, they'd have left the heating on in the room, or they'd have turned the heating off. You recall that famous the bit in The Wolf of Wall Street where they've turned the air conditioning down for tax inspectors and they have to sit in the meeting room with their coats on. All that kind of thing. I do remember. Doesn't happen. And all that kind of thing doesn't happen anymore. And if
give them a lower chair and all that kind of stuff.
Your opponent. Exactly. If your opponents are represented by a half-decent law firm, for example, you can expect probably a decent welcome in their offices. But I mean, for example, if you appointed me as a mediator, as a part of my package, I can offer Clark Wilmot's facilities as a neutral venue. So I can offer one of my firm's officers as the venue. There is also an excellent place in London, just off St Paul's, which is a custom-made centre for dispute resolution. It's got facilities for mediation. It's got facilities for arbitration as well. It's got catering facilities. And actually, this is going to sound really flippant, but catering facilities are really, really important because people that aren't well refreshed and relaxed and well fed will make bad decisions. So it's really, really important that you have tea, coffee, water, sandwiches, biscuits, all those things, and access to toilet facilities. All those things are really, really important. So wherever you mediate, verify that the venue has got those facilities. Because you will need them in the course of the day to remain comfortable.
Yeah, and
mediation. It could last for 12 or 15 hours. So you need to make sure that everyone is refreshed during the course of that process.
You said exactly what I was about to say. Is that from experience, I know mediation can take a long time, and I've got. Even myself, but friends that have done conflict resolution, and one of the things that often depends on the situation, but often some situations can be the start point is we're not leaving here till we resolve this. So you can be there for a long, long time. So I think that's really important. Yeah. Okay, Peter. So I think just there's
certainly examples of mediations that have lasted longer than this. But my personal record is 9:30 in the morning till 5 to 12 at night.
Wow.
And the thing is, of course, with mediations is that there's no real break. So some mediators like to have a sort of a slowing down period over lunch. So once the sandwiches are in the rooms of the parties, they'll probably leave the parties alone a little bit. But you're on the go for the entire day. And so if you're mediating for as long as that, a 15, 16 hour period, that is tiring. And like I say, tired people make bad decisions. So again, another sort of idea is to try and get the mediation done within a reasonable time frame and not let it overrun too much because you don't want tired parties.
No, but even if you're there for 8 hours, 9 till 5, it's still a long day, isn't it? That people need what they need.
Exactly.
Yeah. Okay. So Peter, I know again you and I have spoken about this offline, but there is very much a process to mediation. I think it would be useful, I think, to understand how mediation works. Are there some key process steps? I always think they're useful for business leaders to understand. Yeah. If only when they meet a mediator, they can maybe ratify that the mediator knows what they're talking about. Could you kind of just talk us through that?
Yeah, sure. So I'll take you through the whole process from beginning to end. So you decide to mediate, assuming you've got solicitors already instructed. They will, as I mentioned earlier, identify between them and their opponent a mediator, and they'll jointly appoint them. The mediator will then set a timetable for certain things to happen before the mediation. And those normally are the agreement of a mediation bundle. Now, the mediation bundle is the core papers, the core documents that summarise the dispute. Probably some correspondence, almost certainly some pleadings. Probably a good idea to put some offers in there as well if offers have been made. Don't put in other things. So there's no need, for example, for the mediator to see loads of evidence because the mediator is not there to make a judgment or come to a conclusion. They're just there to help the parties come to a settlement. So they don't need to, no mediator reviews the papers to try and form a view as to who's right and who's wrong. I can talk a little bit about that in a minute. Actually, it's quite a challenge if you've spent 20 years as a solicitor doing precisely that, to then disengage your brain as a mediator to not do that. As well as the bundle, it's common for the parties to prepare position papers, and those position papers can take a series of forms. They can be a joint paper where the parties agree, a joint statement, which tends to be pretty sort of vanilla. just a summary as to what the case is and what the dispute's about, who the parties are. They might also do a position statement. Those position statements have to be very carefully crafted because you don't want them simply to be a rehash of what's in the correspondence and the pleadings, because that's pointless. And some parties actually go one step further and send a position paper that's confidential to the mediator only and says, this is what we want, this is what we want to achieve.
Okay.
They're a little bit less common. But they're incredibly helpful for the mediator, you can imagine, because the mediator then gets an understanding as to what the party wants to actually achieve from the mediation itself. Most decent mediators, of which obviously I include myself, would probably want to have a chat with the parties on a Teams call or something similar before the mediation day itself, just to introduce themselves, just to demonstrate that they are nice people. And that they've also read the papers and understand what the dispute's about. And I can mention a bit, Jason, if you want me to, about what I do when I'm reading the papers as a mediator. So
sure.
When I read the papers as a solicitor, I'm trying to look for the legal angle. I'm trying to look for the solution that I can help my client achieve, and I'm therefore trying to make a judgment as to who is right and who is wrong, who's got the strongest case, who's going to win at trial. Now, as a mediator, where impartiality is absolutely critical, those kind of judgment calls are not only wrong, they're probably also deeply inappropriate. So when I receive a mediation bundle from parties who want me to act as their mediator, what I call read it with my brain turned off. So what I'm doing when I read the mediation bundle is I'm trying to understand who the parties are, what the dispute's about, and probably, if there's a monetary value to the dispute, what that monetary value is, okay? So long as I've got those three things covered, then I don't really need to go much further into the preparation. And actually, bearing in mind my 20-odd years experience as a solicitor, it's dangerous for me to do so, because then I start to think, well, this person's going to win at trial, this person's got a good point, and you don't want to, you really must not do that. You must make sure that if you turn up as a mediator, you're not partial in any way at all. The day of the mediation, then, the parties will turn up in the morning, probably around about 9:30. The mediator will come and see the parties individually and just to make sure they're comfortable, make sure they've got refreshments, make sure that everyone's there that needs to be there. And that's a critical thing as well, making sure that the right people are there in terms of people that have authority. There's nothing that irritates a mediator more than to get to a period later on in the day where the gap's narrowing and a settlement's now possible, to discover that actually someone else needs to be consulted to get final authority. So always make sure that the right people in the room in terms of levels of authority, and that therefore a deal is possible. Probably around about 10 o'clock, you'll then start with the opening session. That typically is a roundtable meeting chaired by the mediator, where the parties have an opportunity to say something. Now, as I think I mentioned in the first podcast, it can be anything. It doesn't necessarily have to be constrained to a presentation about who's right and who's wrong legally. It could be about how the parties feel about the dispute. It could even be about what they're trying to get out of the mediation process. Importantly, absolute Chatham House rules apply to mediation. So the process is both confidential, and the parties will sign a confidentiality agreement before they start the process. And it's also without prejudice, so it can't be referred to in the legal proceedings. So it's an open forum where they can say whatever they want. In that opening session, have a think about who does the presentation. It's natural to want the lawyers to do it, because they're the advocates, they're the ones who'd be presenting the case at court. I've seen some exceptional presentations by lawyers, really good, really well thought out, really strong. And I've also seen some appalling ones. And the worst ones are the ones where the lawyer tries to advocate their client's position, because all that does is it gets the backs up of the person they're presenting to, because they think, well, why are we here if we're going to have an argument? That's not what this process is about. And also, it's just simply a rehash of what's been said already in correspondence. So in other words, it's totally pointless. So I think that think carefully about who presents, and also don't let someone present if you've not agreed who's presenting. So don't let someone just go off on a tangent of their own. Make sure that everyone knows who's doing what, who's saying what, and when they're going to say it. the mediator will also talk a bit about the process, a bit about their role, the fact they're impartial, the fact that they are appointed by the parties and therefore act for the parties, the fact they're not there to give advice, they're not there to form a judgment, and they're there simply to try and help the parties through the process. And then once the opening session has finished, the parties will then move into what's closed session. And closed session is where the parties go to their separate rooms and the mediator then shuffles between the rooms to try and narrow their positions and eventually, one would hope, transmit some offers. Now, if the opening session finishes at 11 o'clock-ish, typically you would want the argument to be finished by lunchtime. After lunch, you then want to be starting to look at offers, structuring offers, and then by sort of 5, 6 o'clock in the evening, you would hope typically to be in a position whereby the parties were then negotiating heads of terms with a view to actually having a document they can sign. Now, most mediators, and I would include myself in this, if there's a settlement, you want a binding document at the end of it. So you want a settlement agreement that the parties sign up to. And the reason for that is you don't want parties to walk away from a mediation and then have buyer's remorse and suddenly think, actually, that was a terrible settlement. I don't want to go through with it. You want them to have signed something. Now, most parties at a mediation, not all, but most, will be legally represented. And so they'll have advice as to what the settlement agreement means and what the outcome of the settlement is going to be. But I think the mediator wants a contractual commitment from the parties to each other to a settlement to make sure that settlement is entirely binding. The process itself, as I say, is voluntary. So actually, there's nothing stopping you leaving at any time if you want to. But I think if you are going to leave, you have to make sure that you've communicated your intention to leave to the mediator so they know what's going to happen and didn't come as a nasty surprise. And it also has to be on the basis that you've exhausted everything. You've tried everything and it's not worked. To leave too soon in the context of the process, not too soon in the context of the day, is, I think, extremely unwise. So I hope that's a sort of a brief walk through the process that's covered off what you could expect if you ended up in a mediation.
No, I think that was a really good overview of the process in the short time we've got, but also some really good tips within it as well that I'm sure people will find really, really useful when they listen to this. Look, Peter, we're out of time, unfortunately, but there's, again, so much really good insight there and some great tips for people. So I really, really do appreciate your time. I'm not going to try and summarize that because there's too much good stuff in there. I'll let people pick their own highlights from that. But I think maybe just for you to finish, maybe give us three top tips on when and how to use mediation for you. And could you maybe make one of them almost a non-mediation one, maybe as a business leader in terms of a top tip for mediation in business, and then another 2 professionally?
Well, I think, it's an effective process. It is a process that does generally speaking, lead to a resolution and therefore avoids the cost and time of trial. I think you have control, so that's a really, really important part of the process. You dictate the outcome. Obviously, the outcome is also dictated by how reasonable the counterparty, your opponent, is in the process. And I think, as I mentioned in the first session, it buys back time for you as a business leader. So you're not then committed to a dispute that's going to take up a huge amount of management time going forward. It enables you to do what's important, which is to focus and concentrate on your own business.
Yeah, thanks, Peter. I think, I think that I took from that, there's a process. So I think, there's clearly so many benefits to doing mediation. I think in my head, I'm just saying, just do it and trust the process. There's clearly 100 reasons that we've explored why people should do that. Peter, thank you again for joining us over these last times. It's been really, really useful. If in our next episode, we're going to have a bit of a segue. We're going to look into the cyber world. We're joined by a couple of guests that are going to talk to us about, in the context of being a leader, what we need to be watching out for in this cyber world. What are the risks for us, really? I think some interesting conversations as well about, as we sort of adopt AI and chatbots, what we need to be thinking about before we really start to integrate it into our business. So that's going to be an interesting subject. But in the meantime, anything else you need to know on mediation, feel free to reach out to us at directors-circle.com. And Peter's always available at Park Wilmot, and I'm sure you can find him through LinkedIn. But in the meantime, thank you for listening to Inside the Directors Circle.